evening, everyone. It's very nice to be here in Mangalore. Thanks to Vishwas Rao giving me opportunity to be here today. So I will be talking more specifically on artificial intelligence and intellectual property rights. Uh, Artificial intelligence as a subject is penetrating all areas of day-to-day life, and question there are lots of legal disputes related to usage of AI. So as you know that intellectual property means anything which is created out of human intelligence. Now what if the same intelligence is created by a machine? Okay, so have you ever used chat gpt and created a content? I think all of us. So who owns that content, whether machine owns that content or I own the content? If machine owns the content, then how we are going to establish ownership of that particular product? Yeah, next. Can can anyone recognize this person? Can anyone recognize this scientist? Anyone from the audience? So he is John McCarthy. He is the first scientist who coined the word artificial intelligence. And artificial intelligence, by the way, is not a new subject. So first time the term artificial intelligence was used in 1956, and then he actually coined definition of artificial intelligence as a machine which generates intelligence. And yeah, next please. Artificial intelligence is the science of making machines that can think like humans. So what we do in artificial intelligence is that we create very complicated algorithms which start behaving like a human being. So the outcome of artificial intelligence is more or less like the way human thinks. Recently Sophia, robot, was given citizenship. So that means there might be a possibility of treating a machine like a citizen. So if a machine can invent, then can machine own also? If a machine can own any IP, so tomorrow any disputes happen and there are damages to be paid or there is penalty to be paid, then would a machine be liable to pay or a human being is liable to pay? So if you look at the global market of AI, it's phenomenal. Every industry, every area of science today is AI enabled, and the world is going to face a circumstance wherein the AI market will grow multiple fold, and we are in a stage of history when we are witnessing that AI is going to help us. But at the same time, we need to have right policies, right processes to make sure that this technology does not harm human population, because all over the world we are already witnessing that lots of jobs are getting lost because of AI. And also we cannot ignore that science always had plus and minus about it. Whenever science grew, there were negative things also along with that. And there was a time, but on the other hand, there was a time when computer was invented. People thought that now this is the end of the world, computer can do everything. So now we are again into the same era. We feel that with AI everything will get disrupted, but that might not be the case, because with time things will settle down and we will accept AI as part of life. At the same time, there will be opportunities for everyone to grow further using AI as a base. Intellectual property is creation of human mind, and this creation of human mind can be of different types, different shapes. It could be design of a product, it could be a computer program, it could be a secret recipe like we have in Coca-Cola. It may be a drug formulation. It may be a vaccine. So the generally speaking, IPR is nothing but creation of mind. Creation of mind can take any form. It can take a form of a book. It can be article. It can be a vaccine. And depending upon the kind of intellectual property you have created, we have to figure out how to protect it. If it is design of this mic, then aesthetic look and feel of the product has to be protected. And if it is a vaccine, then maybe the process of making vaccine can be protected. But at the same time, there are many products wherein you can best protect it by maintaining secrecy of it. Your kitchen recipes. Okay, your grandma, same kitchen you use, but taste of your recipe will not be same as your mother cooks or your grandmother cooks, because there is some secret right time of putting the ingredients, right temperature, whether lid should be put or not. So these all are trade secrets. They are maintained very well by keeping them as a secret. Coca-Cola is one of the examples wherein the recipe is best protected by maintaining secrecy of it. When it comes to protection of intellectual property, there are mainly three ways of protecting it. One is you simply register it. Okay, if it is name of your product, we have a lot of startups here. Name of your product, name of your company, name of your business, services, product, it should be registered as a trademark. Trademark is one of the very important kind of IP. People mostly talk about patents as IP, but in my personal opinion, trademark is the most important form of IP, because I have seen people losing their trademarks after 10 years of usage, 12 years of usage. Just imagine that you have been, because you fall in love with your company name or your product name, and after 10 years, 12 years, 15 years, you feel that you don't own that. You lose it to your competitor because it was very similar to some other brand which was much bigger than you, and they had all the ways and means to stop you from using a particular brand name. So brand name has to be taken very seriously right in the beginning. Select your marks very well. Make sure that they don't resemble any existing brand, because as a user of a product, you tend to be inclined towards very generic names. Like if it is a soap, maybe wash well will be the name you will opt for, but later on it gets rejected. So registration is one of the ways you can protect your brand name. And second could be, sometimes it's important to protect your IP by having contracts with the third party, to whosoever you are going to disclose it to. At the initial stages of your business, when you have to disclose your invention or the innovation to investor, then contractual relationship between two parties is something that is helpful to protect your IP. And third will be, you can keep it secret. Don't disclose it to anyone. So if you feel that your IP cannot be reverse engineered by anyone, then I think trade secret is a kind of thing you should be looking into. Mainly four kind of intellectual properties are important for any business: patent, copyright, trade secret, and trademark. These four are important forms of IP. Even though some of the products may come under regime of trade, the design, but here today I am talking more specifically with respect to your artificial intelligence. Copyright in AI products. If you have not watched this movie, please do watch. It's worth watching. I've watched it once, but I want to see it one more time. It's a very brilliant movie. In fact, everyone in the family, especially your kids, should watch it. So in AI products, algorithm is something which is protected by copyright. Okay, so when the product is ready, algorithm can be registered as copyright. And good thing about copyright is that there is something called as Berne Convention in copyright law. So you register your copyright in any one member state of Berne Convention, and automatically you get protection in all member states. So which means that if you register your copyright in India, you automatically get protection in close to 180 countries, and it's very affordable. It's one-time protection. And you must go for copyright for your algorithms if required. And in copyright, you have classes like literary, artistic, cinematographic, musical classes. So selecting the right class, you can register your copyright in that particular class. Next, please. Trademark, I think I have talked enough about trademark. So take your business names very seriously. Do a trademark search right in the beginning and make sure that your trademark does not resemble any existing trademark. It has to be unique. So mostly in trademark, self-coined terms are very much preferred. Inalsa, then you have Ola, OLX. These are self-coined words. Yulu bikes. So they are registered very easily by trademark office. And I have seen a lot of businesses, rather than focusing on the businesses, they are now handling trademark litigation. So which is not really worth. Then comes trade secret. Trade secret is any secret which you feel is difficult to reverse engineer. You can choose to maintain it as a trade secret. Many companies have been choosing to keep algorithm also as a trade secret. Only one condition is required to be fulfilled to keep a trade secret, that if I take your product in my hands, I should not be able to reverse engineer it. If I can reverse engineer it, it is not a strong trade secret. In order to be a strong trade secret, it should be almost impossible to crack the recipe or crack the algorithm. So, if it is difficult to or impossible to reverse engineer, I think it is a trade secret and you can always protect it. And best thing about trade secret is you don't have to hire any attorney like us. So you can just have your own processes, your own policies to protect your trade secret. And life of trade secret is perpetual. As long as your trade secret is a secret, it has value. The moment it is out in the industry, it does not have any value. Now, coming to AI related inventions, there are two aspects of AI products. One is the product itself, AI product itself, like ChatGPT, and second is outcome of that product, which is like the content which ChatGPT is producing. So, when it comes to the product, AI based system or AI based product, then in India we have some parameters wherein we prohibit giving patents on software related inventions till the time there is a technical effect or technical advancement produced by the software product. So if a AI product has some association with the hardware, it becomes very easy to patent it. It's easier to convince patent offices that okay, I have a software product, but it has hardware components. So together I can register it as a patent. But if it does not have any hardware component, then it is usually challenging to register it as a patent, not only in India, but also in the US these days. Earlier, there was a perception that if not India, US will grant you a patent, but now US also does not grant patents on pure software. And Europe and India, they were always like more or less same as per, because Britishers ruled us for so many years. So Indian laws, they always have impact of European system. So Europe follows India and vice versa, but there is close similarity between laws of Europe and laws of US. So in India, the definition of invention which can get a patent is that it has to be a new product, new process, which has industrial application plus technical advancement. Okay. Yeah. So just to summarize, novelty is required. Next is inventive step, and next is industrial use. So novelty in case of the inventions which are produced by AI is always a big question mark, because if I made ChatGPT to invent for me, then can I ethically be called as owner of that invention or not? Is always a big question mark. And then very interesting to note here is next slide, please. Yeah, in addition to fulfilling these three conditions, we also have to see if the software invention falls under preview of Section 3 of Indian Patent Act, which says that software per se is not patentable till the time it has any technical effect. Novelty in case of AI related inventions. So the journal definition of novelty is that your invention should not be anticipated by any existing prior art. So there should not be any patent, there should not be any paper publication, there should not be any use of that invention in the world. So prior art search is always done globally. So novelty in AI related innovations is difficult to determine, because AI system would have been trained to produce a particular output based on the data that has been fed to a AI system as a input. Now, one of the conditions to get a patent is that invention should look to a person having ordinary skills in the art. That means if I invent a software, my invention should look good to a person who's a software engineer, okay, person with ordinary skills in the art. So that person doesn't need to be a very Nobel Prize winner and all. So if it is a biotechnology invention, then it should look good to a person who comes with biotechnology background. But when you have AI related inventions, then who is this person skilled in the art? Okay, so we are raising standards of persons skilled in the art also as per patent law when you have AI as an inventor on the other hand. Section 3 of Indian Patent Act says that mathematical business methods, computer programs, algorithms are not patentable if they don't have any technical application. They don't result in any kind of technical advancement. And we in India, we have computer related inventions guidelines, but we don't really have any guidelines for AI. But just 2 days ago on Valentine's Day, US released first round of guidelines for AI related inventions. Yeah, next please. So the main issues related to AI is subject matter. What should be patented, what should not be patented, has to be clarified. And then second is how do we determine inventive step. But most important issue that comes up is ownership. Who is going to own? If I write article, if I want to write article and I take help from Chat GPT, okay, give me best places to visit in Bangalore, and one nice write up comes out, then who owns it? Do I own it or machine owns it? If I want to register that article as a copyright, then in whose name shall application be filed? So at this point of time, I think the legal system is confused, people are confused, and lots of case laws are getting generated to address this. And different courts across the globe, they have given different kind of judgments. But end of the day, the thing is that we need to have a unified kind of system wherein we establish a machine or a human being as innovator or inventor. Now let's understand what the law says. In India, patent has to be filed by true and first inventor. True and first inventor is the person. It has to be living person with 4 limbs, breathing, alive. Okay, so true and first inventor is a person who conceived the idea. So if you conceive the idea, then you become true and first inventor. So if I'm working in a institution, if I'm working in a university, then I invent something. So my name in the patent application will be as an inventor of the patent, inventor of the invention, and I may assign my application to the university, wherein the university becomes the applicant, but my name remains as inventor. So inventor has been given a very high regards in patent system throughout the globe. If my invention gets stolen and I suffer because of that, then patent office is going to address it on my application. But true and first inventor is something which is non-negotiable. I sell my technology transfer happens. You sell your patent from A to B, B to C, C to D, but inventor's name never changes. It remains on the application as inventor. So, true and first inventor always gets a patent, and inventor always has to be a human being. It cannot be a machine. Next. This was a very important and very first case when the patent was filed in the name of AI machine, device for autonomous bootstrapping of unified sentience, that is DABUS. This was a machine, AI machine, and this was created by Dr. Stephen Thaler. So Dr. Stephen Thaler filed lots of patent applications, but 2 important inventions this machine made actually. One was for beverage container, and second was flashing light for attracting enhanced attentions. Now these 2 products were invented by the machine, and then Dr. Stephen thought that, okay, I'm not true and first inventor, maybe this machine is true and first inventor. So he filed his application in a US patent office. Next please. So he filed his application in UK, US, Australia and India. So India rejected. First of all, India said that this application failed to pass formal and technical examination because DABUS is not recognized as a person, natural person, as per Section 2 of Indian Patents Act, which is like, I feel it's logical. Next please. Then this application was also rejected by US Patent Office, UK Patent Office, Australian Patent Office also rejected. But then later on, Federal Court of Australia, they accepted this application, saying that DABUS can be inventor. So now machine becomes inventor of the inventions. But later on, there was a bench of 5 judges in Australia. They again rejected the application, saying that machine cannot be owner of any invention, because it's not just filing application, but it also is like tomorrow any litigation happens. Okay, so in that case, whom to whom to blame for and how to proceed with those applications. So now the thing is that expanded 5 judge appeal bench of full federal court reversed the judgment and brought Australia back into line with the position taken by other nations. So as of today, the law across the globe is that machine cannot own any invention. So when this question was asked by Dabus, so he asked that if not machine, then who should own this invention? So there were certain, possibilities proposed by Australian Patent Office itself. So Patent Office said that either the owner of the machine can own it, okay, or the developer of AI software can own it, and the developer who has developed the software code can own it. And if a person who is giving input to the machine to generate a desirable output can also be inventor, but end of the day, you take any combination of it, but end of the day, it has to be natural human being, legal entity, which can own a patent. In Beijing court of China also, it was held that human production or creation is prerequisite for copyright protection, which may exclude AI software as an author. Just 2 days ago, US Patent Office, they released some first guideline in the world has come up. So US Patent Office said that machine cannot own a patent. Patent has to be owned by a human being only after providing. They said that you can refer a AI system to invent something, but final shape of the product has to be given by a human being. And I think with time, patent offices would also ask the inventors to show the prototype if it is like AI related invention. And US Patent Office also said that if it is realistic, invention is realistic and you have put enough efforts, then you don't even need to disclose to patent office that it is generated by AI. If you see beautiful images you can generate using AI, images are so beautiful. You can't really, you don't really feel of having paintings, handmade paintings done, because you really get brilliant. In the movies, you see the AI generated images, they look really very beautiful. And when it comes to copyright, the fundamental rule is that copyright is not granted to idea, but the way idea is expressed. For example, if it is idea is a love story, then the way different directors make love stories is different expression, and all these expressions can get copyright. But when it comes to AI, now you want to search images of Lord Rama, then you can generate any kind of pictures using using AI. But now, do you own it, or who owns those images is always a question mark. But there have been some case laws here again. This was the first case that came up in the US, Anderson versus Stability AI et al. In this company, 3 artists, they sued the company saying that the images which AI system is producing is violating their copyrights, and they should train their system in such a way that it does not violate third parties' IP rights, and the AI should also be trained to take licenses from copyright owners in such a way that their rights are not touched upon. So this was first case when 3 artists, they formed a class to sue multiple generative AI platforms on the basis of the AI using their original work without license to train their AI in their style, allowing users to generate works that may be insufficiently transformative from their existing protected works, and as a result would be unauthorized derivatives of that particular work. In another case, Getty Images is a company. They have images, and they give some images are royalty free, but they charge to give images, to sell the images to the users. So Getty Images, they had around 12 million images, at least 12 million images that were copied by different AI systems. But end of the day, AI has to be trained. AI works on the data you feed, and AI has to be trained to ensure that third parties' IP rights are not violated. And if those rights are to be used, then adequate licenses should be taken from the users. Then this was a case of Som Prakash Lekhi versus Union of India. In this, this is one of the good Indian cases. Here, Supreme Court held that since AI does not fulfill various essential conditions like power to sue or get sued, it cannot be considered as juristic person and law cannot attribute duties to it. Therefore, patents cannot be granted to any AI generated content. And court also said that necessary human intervention and the role is a prerequisite, and therefore in order to obtain a patent for AI generated content or novelty, it would be necessary to have a human force behind it which shall be eligible to obtain a patent. How can you mitigate the risk of violating third parties IP rights? First is that you have to read through the data privacy policies. You are feeding your AI system with some initial data. You have to protect data privacy laws. Data privacy laws are very strict in Europe, US, and in fact now in India also we have data privacy law now. So you have to comply with data privacy law. Then term of use privacy policy of individual site has to be read, and licensing option has to be worked in the cases wherever it is required. And there are some well established ways to have IP pool also, wherein licensing becomes very easy. And with time, I feel some definitely some organizations will work on it and will have bigger patent pool. Yeah, next please. And AI models, they shall be trained to review the term of service, privacy policies of the sites from where it is taking the data, and users should also be vigilant about what they are using and what they are not using. So just to conclude that AI ML, they are new subjects, they are very good. I mean, it always has pros and cons. They have made life very easy, but at the same time lots of people, they are losing the job. There is lots of confusion related to the content that is getting created. So there is a very dark side also of artificial intelligence. And with especially with respect to the area of IP, how to protect AI product and outcome of AI, how to assess novelty, inventive step, who is going to own AI related product, and how to prevent violation of third parties IP. They are going to be very crucial issues, and I think following US, other countries will also devise the guidelines to protect AI related products. And I represent my organization, Origin IP Solutions. We help companies protecting their IP. We provide end-to-end consulting on patents, trademark, copyright, designs, etc. And we also undertake very wide range of legal documentation, policies, contracts, and we help companies commercialize their IP. And we are also into mergers and acquisitions of companies. I think in due course of time, with so many startups in the country, time will come that when lots of mergers and acquisitions are destined to happen in the country. If there are any questions from the audience, maybe one or two questions can be taken up. And if you have any inputs to add, don't hesitate.
Hello. Ma'am, if I'm setting up, let's say, 10 data points on which an AI is going to build a model or a solution, or it could be any product. Uh, so the initial data points or the initial set of ideas or rules were set by me, right? So wouldn't AI can also be just looked at a assistant or let's say a team of people of your own? Because isn't AI just reducing the manual labor also in some industries? Let's say we were talking about biochemistry or pharmaceutical. Let's say we want to do 10 iterations to come to make a chemical. But if I can bring in mechanical and electronics and AI combined together to make iterations of chemicals, and have 100 missions doing it at the same time, wouldn't all of that also say that I'm actually contributing like 95% and just the AI is only using, you know, uh,
Yeah.
at that point, what would they say? I mean, what would
See,
the,
the important keyword here is human intervention.
yeah.
Right from the conception of patent law, the word has been used as human intervention. So, if you can justify that there is human intervention and the outcome is executable,
To stay informed about the startup ecosystem, subscribe to My Startup TV.